Good morning. I hope you can all hear me. You can't get much more 2022 than digitally moderating an analog panel. So let's see if it works.
We can't hear him.
You can't hear.
I'll tell him to get on with it.
Okay, so 10 or 15 years ago, the Venn diagram of democracy versus countries with data protection laws was more or less an uninterrupted circle. Now the correlation is weaker than ever. Data protection laws have proliferated around the world, but democracy is in retreat. In Europe, it's no longer physical assault with Russia's invasion of Ukraine, but more chronic and insidious forces undermine it from within. According to the latest Freedom House survey, the proportion of the world's population living in a free country dropped from 46% in 2005 to 20% today. Data protection without democracy means selective protection of rights for the strongest only. If you're poor and your data protection rights are infringed, what realistic chance do you have of seeking remedial action and justice? A global tech giant, on the other hand, can not only protect their secrets through a wall of NDAs, non-compete clauses, and injunctions, they can also defer justice seemingly indefinitely, as we've seen, for example, with the Beckettian stasis that has followed not one, but two judgments handed down by the EU's highest court on the question of transatlantic data flows. Meanwhile, for those frustrated at the apparent impotence of democratic institutions to enforce the law, China's Communist Party and other autocracies offer an alternative to bringing the most powerful private actors to heel through a mixture of coercion, censorship, and involuntary disappearances of CEOs. And amid the hand-wringing over the GDPR's delayed gratification, a new suite of laws has emerged which takes specific aim at certain business practices of dataopolies. These include the DMA and the DSA. But what can we expect to change so long as these innovative laws are superimposed on existing structures of market power, social inequalities, and pressures on the rule of law? We have some excellent speakers to discuss these questions. Barry Lin is Executive Director of the Open Markets Institute, and his work on 21st century monopolies' impact on democracy, individual liberties, security, and prosperity has been hugely influential, not least with the Biden administration. René Repassi is a member of the European Parliament and a member of committees for the Internal Market and Consumer Protection, Economic and Monetary Affairs, and Legal Affairs, and he's also Professor of Public and Private Interests at Erasmus University. He was Shadow Rapporteur for the DMA. Cristina Caparra is an expert in competition economics who has led for several years the antitrust and regulatory team at Charles River Associates in Europe and has written extensively on the need to integrate competition enforcement and data protection. And Johnny Ryan is a senior fellow at the Irish Council for Civil Liberties, a senior fellow at the Open Markets Institute, and an internationally renowned expert on surveillance, data rights, competition and privacy. My name is Christian, and as I work for the European Commission, I should stress that moderating such a panel does not equal endorsement of the views that are about to be expressed. Johnny, you've traveled the world telling lawmakers about the business models of all powerful companies and their harmful effects. For the last decade, all of our hopes and dreams have been invested in the GDPR. Is it fair to expect the GDPR to remedy these concerns? Tell us about the intersection of data protection and competition law and whether we're doing enough.
Thank you, Christian. And the microphone is on, so we're winning. Let's see if we can get the slides up on the screen. I have some slides to answer exactly that question. And first, let me say, it is really nice to be back with you. And I look forward to having an intoxicating drink with you all later. Now, on to the bad news. The first bit of bad news is that we came up with an incredibly long title, I think it was your fault, Christina, for this panel. And I think, actually, that the title of this panel needs to be shortened, because what we're talking about is something really simple. Today, at this event, I suspect there is probably nobody, I might be wrong, but I suspect there is nobody from the European Commission Directorate General for Competition present in the whole event. Now, I might be wrong, there might be one, but I think there should be many, because the key issue that we need to discuss is competition. And we need to be thinking, I think, as a community back together for the first time in 2 years, we need to be thinking, how do we help DG Competition? Because it has a job to do, and it doesn't necessarily seem to be cracked just yet. On the screen, you are seeing what was regarded as a titanic achievement. These big fines in competition cases, in this case of Google, by the European Commission. Now, these were rightly hailed, they were rightly greeted as an assertion of Europe as a regulatory superpower. But let's have some perspective. In the same year as that last fine, Google's revenue that year dwarfs those fines combined. And let's take a look at the last annual figures. For anyone who's taking a picture of this slide, it gets even better. Because those fines were not a curb. They were not a break. They did not stop or fix the problem. And I'm not suggesting that revenue is a problem, but I am suggesting that the Commission has not yet grasped what they're dealing with. And I think we, in our community in data protection, know things that can help them. And it is up to us to communicate that to them. Now, let me start off by straying wildly from the point. So far a tangent that I'm going to take you to 1665. This is the title page of Micrographia, a book that Robert Hooke wrote in 1665. Robert Hooke, father, or one of the father figures of Britain's scientific moment. And among Hooke's many talents was that he ground his own lenses. And in this book, Micrographia, he showed people what he could see with these magical lenses, and he could blow things that were small up big. So after a third of a millennium living with fleas, we were finally shown what the eyes of a fly looked like by Robert Hooke in 1665. I show this to you because also in this book, Hooke introduces us to the idea of a cell, or a bladder of air, as he called it, a cavern. This is the first picture we have of a cell, and it's a cell from a piece of cork. Now, I show this to you because without this picture, there is no modern medicine. There is no modern biology. You need the quark, you need the atom, you need the elemental particle, you need the infinity stone, whatever it is, to start building things from. So if we are going to help competition colleagues think about digital and data, one way we can help them is to give them an atomic unit for the accounting of the use of data inside organizations. And conventionally, you'll talk to an engineer or a computer scientist, and they'll tell you about Claude Shannon. They'll tell you about the byte or the bit, but it's not the byte or the bit. The byte and the bit are simply the unit of account of information. But we want the unit of account of the use of data inside an organization. And of course, we know, because European data protection law has told us for a long time, that this is the processing purpose. So here it is in its latest incarnation in Article 5.1b. And let's take a look at the processing purpose in all of its glory. Taking out Robert Hooke's microscope, we're now going to look at some personal data. This is what they look like. Now, they should be wrapped tenderly in really sharp barbed razor wire. They're supposed to be kept in little ring-fenced boxes called processing purposes. And you're likely to have more than one, even for the same piece of data. Now, we know from European court case law that the scope of an individual processing purpose is based on what a person can guess the data will be used for when they hand over the data. So let's now take Hooke's microscope from 1665 and look at any modern organization. We have a few DPOs and former DPOs in the room, and they will all recognize this picture because, of course, this is what every organization looks like internally, except, unfortunately, it does not. It should look like this kind of arrangement. But actually what happens is Christina and Johnny set up a business delivering pizza by drone all over Europe. And it turns out the Europeans love cold pizza from above. So we end up with loads of people's credit card details, home addresses, and so on, for various purposes. But Christina is a rapacious capitalist monster. And she has all of these other things that she'd love to do with your data as you munch your pizza. She wants to get into some other business, like taxis, ride-hailing, whatever. So she does a kind of a Berlin airlift and drops the data into all of these other processing purposes and reuses it. She cross-uses it. She abuses it. She enthuses it. The problem is, though, that our business, although this makes us incredibly dynamic, is now incredibly vulnerable to any enforcement at all of the purpose limitation principle. Imposing that principle on us would not be like a heat death of the universe. It's not the thing in reverse. It would be the opposite of the Big Bang. And the problem for us is that what made us dynamic, our abuse of data, our reuse of data, is what makes us vulnerable. Now let's make it more practical. And I'm going to blame Christina again. We are going to make a lot of shareholder value and maybe even some of that consumer welfare stuff. We're going to get really big in one market, delivering pizzas by drone. And then next year, Christina will say, let's get into health insurance. And she will take, I'll agree with her because it's a good idea. She'll take all of the data from market one and drop it into market two. Now, in competition terms, you could say that's offensive leveraging, right? And it's so successful, we'll keep doing it. And this should be very familiar to anyone who's following the Bunz Cartel Amt case, because this is basically, I'm back a slide. This is the model of Facebook. Now, what the Bunz Cartel Amt has not looked at, though, that I'm aware of, is that the issue is not just the sharing of data between subsidiaries of a conglomerate. The issue is also the cross-use of data within each subsidiary across processing purposes. So actually, our business will look like that. And now let me give you an even more concrete example. Let's imagine that you have gone out and bought for €800 an Android phone, for example, right? We'll pick on Google today. They can take it. Now, Google will nudge you very affectionately, but very definitely. They will nudge you to set up a Google account. Let's stand back from the majesty of this copywriting. You'll scroll through a whole lot of nonsense to get to this point, and unless you're a total masochist, the last thing you want to do is click this euphemistically termed more options. But just bear with me, and we're going to do something that will feel like self-abuse, and not in a pleasurable way. We're going to click more options, because I like options. And now we see web and app activity, which is euphemism the second. 3 things pop out of this paragraph, and I will pop them out for you. The first thing, we are told everything that I do on my phone or across any property of this company will be hoovered up. Forget purpose limitation. Second thing, anything on any other company's stuff with which we have any connection. Maybe we provide infrastructure. Maybe it's through Google Fonts. Who knows, right? Who knows? So we're going to combine everything, what they own, what everyone else owns, and finally we're going to combine it in a big tub and mix it around. And just to make sure this is completely unlawful, we're going to pre-tick this by default and hide it under more options. Now, this preamble is before 3 suggestions. I think we in the competition community, data protection community, should be actively involving and convincing and helping and supporting our colleagues in the competition community to do 3 things. The first thing is to fix a problem. Here's what the problem actually looks like. You buy your phone, this is roughly what happens. Pick a company, but this is roughly what happens. Now, let's explain this as a competition problem. In market one, I'm way over time, I know. In market one, from maps, you can know that I have a hearing problem, for example, if I did, and go to a particular sexual orientation venue and a particular medical center, just because my location will reveal these things. In market two, where the company is providing an advertising system for a publisher, of course the company can know everything I look at on that publisher's website or app. By the time we get to market five, where the company involved, in this case Google, is showing ads at a far higher margin on its own properties, Google, YouTube, for example, it can use everything it's learned in market one, market four, market two, market three, and about 90 other markets. Purpose limitation is a lobotomy. In competition terms, it can enable something like, not to be correct at all, I'll misuse this term, but a functional separation. And the mental image we should be thinking about here is HAL 9000. Because near the end of the film, before Dave Bowman takes all of that psychedelic stuff, he's ripping the brain chips out of HAL 9000's brain. And that is us as individuals. And HAL is Amazon, Google, Facebook, whoever comes next. That's where we should be. So that's where we are now, or where we want to be. Let me show you where we are. This document is from the Northern California case against Google. It came out under heavily contested discovery about a month and a half ago. And in it, Google says, we collect data in a huge bucket and allow it to flow wherever and whenever. Even we can't trace it. And when I did try to trace it a few years back, this was the ROPA, the list of processing activities that I could try to cobble together. Hundreds and hundreds and hundreds of cells. So the first ask, and I'm way over time, is that the competition community needs to hear from us that purpose limitation is big tech kryptonite, when big tech is not getting big on the merits and when it's misusing personal data. The second of these three requests is to start thinking a little bit differently when one company wants to buy another one. Company A walks into a bar and is looking around for attractive companies. Luckily, the competition authority understands Company A forensically because it has obtained a list of every single processing purpose. When Company A gets together with Company B, the actual question I think that our colleagues in competition should be thinking about is, what happens when these two spreadsheets make babies? Right? This is what a competition analysis of a merger, I think, should look like. They do not have these spreadsheets, and they do not have purpose limitation as a concept, as far as I'm aware, that they are currently considering. In a sense, we're sitting on it, and we need to give it to them. Now, this would have applied very well for DoubleClick, for Fitbit, for anything else. And let me leave you with a third request. We have a thing which, like the GDPR, may be nothing at all, and it's called the DMA. Let's see if it is a thing. One thing that the DMA does, unfortunately, is create a bit of ambiguity about purpose limitation, because it uses this language of their specific choice for gatekeeper companies, big tech firms, being allowed to combine all data. Now, this does not supersede the GDPR, but just because that's what the law says does not mean that it reflects what will actually happen. Now, I and some others had hoped that that text would change to make explicit the role of purpose limitation. Alas, that did not happen. And we run the risk that people across this market, let's call it a market because we're thinking in competition terms, will be confronted with this. And with the click of a single button, they will opt in to an internal data free-for-all, and it'll take us half a decade in court to try to fix that problem. So I'm way over time. I'm leaving you with three requests. DG Comp, the European Commission Directorate General for Competition, has three things that we can help it with. It can use our tool of purpose limitation to tame the giants. It can use our tool of purpose limitation to better understand these companies and to have a proper merger analysis that is forensic. And finally, it needs to hear from us so that it is very active very early on the DMA. I will finally end my monologue. Thank you.
Thanks, Johnny. That was great. You've used up more than your allocated time for this panel and probably for all future ones. But thank you. Christina, let's come at this problem from a different perspective. Why are we again talking about competition at a privacy conference? Why should market power be tackled through data protection tools? And what support can be given to DPAs?
Thank you so much, Christian, and it's a pleasure to be here. I have nothing like the colorful slides of Johnny, nor his walking up and down the stage, but I thought I'd perch on this rather than sit down on a low seat. So to begin with, disclosure, I am the rapacious capitalist, and I come from the private sector, and everyone who comes from the private sector has a duty to disclose. I have done work adverse to Google for multiple years, both for private clients and agencies. I assisted the Texas State Attorney General in their investigation. I've done work adverse to Facebook. I've done, in the last 3 years, some work for Amazon, Apple, Netflix, Uber, Microsoft. Okay. It is quite shocking to me that I am the only antitrust person in this amazing conference. I looked at the program, and there's perhaps one lawyer I recognize, no one else coming from the antitrust world. And this is remarkable when you think that the antitrust world is where the decisions are actually made, which creates these enormous amounts of market power through mergers. People like me and lawyers troop into DG Comp day in, day out to say that a particular merger is marvelously pro-competitive and engage with DG Comp every day on this point. This is also the world that ultimately is dealing with these amounts of market power that are being created, exposed, trying to somehow deal with the runaway effects of these market powers. And Johnny has mentioned the enforcement by the European Commission against Google, Google Shopping, Google Android, Google AdSense. These are all cases I've been involved in. There are cases against Amazon. There are cases against Apple. None of which, I have to say, is actually managing to change things on the ground very much. And the disturbing thing is that these huge amounts of market power from which everything in many ways derives are allowed to be created, to come into being, because effectively almost no merger is blocked. Let's pause and consider this fact. There is a well-known statistic that says that there's about 1,000 deals which have been consummated by GAFAM, if you like, in the last 10 years, most of which have not only not been blocked, not only not been vetted, most of which have not even been looked at in any way. And even in the very few cases when things were looked at, Google DoubleClick 10 years ago, Facebook WhatsApp, Facebook Instagram, frankly, they were got spectacularly wrong in terms of the implication of this. There are many of these deals that are passed today, that are approved on a daily basis, that are killer acquisitions, that are reverse killer acquisitions, which are motivated by acquiring a position in an adjacent market, then leverage your position with data, create a deeper moat, and so on. And then, once you've created the market power, of course, there is almost boundless ability to exploit it through conduct, tying, bundling, leveraging, excluding, foreclosing, doing almost anything, a power that is actually untamed, because with all the good intention of the antitrust agencies, this stuff has been pursued with some effort, but the reality is the results on the ground haven't changed. Antitrust has really floundered in this space, which is why we are trying to see whether a regulatory framework like the DMA or the DSA can do better. But the troubling thing for me, kind of looking at this as someone who very much believes that data is at the heart of many of these mergers, and data is at the heart of the conduct that we're worried about, is that we are continuing to proceed in silos as communities. There is the antitrust people over there, and they have no idea what you do. No idea. They say, we do market power over here, sorry, the data protection people do their thing. And on the other hand, there is a sense that data protection is being made more difficult inevitably by the fact that you have this enormous market power to deal with. So data protection agencies who have got to deal with giants, effectively, when the giants are not tamed, when the monopoly power is in no way controlled, are having to go out there and fight against giants with plastic knives. So this is a crisis which is going two ways. We are not effective at taming the market power, at preempting the creation of market power. We have allowed and continue to allow grotesque amounts of market power being created and pursued. And at the same time, we are not making inroads in combining the insights of this community into the assessment of that market power and how we should deal with it. This is something which I feel incredibly strongly about because I think this community has, as Johnny explained, tools and insights that are very invisible to the antitrust authority. There is no real understanding. And in part, it is a fault of the profession. You know, I'm an antitrust economist. We come from a Chicago tradition. Look, if you talk to an antitrust economist and say privacy is a fundamental right, we switch off. Don't care. Don't care. Because we don't deal with things that are fundamental. We deal in trade-offs, okay? So what's the benefit? What's the cost? We think about this in those terms. So if one goes and engages with the antitrust people talking about fundamental rights, forget it. At the same time, there is a sense in which economists in particular and antitrust people have been trained to think that more information is good. We want perfect information. We want as much information as we can because then we can make products that people want because asymmetry of information is not a good thing, right? We want products that are better informed by data. So if you actually ask the economists inside DG Comp, their posture will be, why is it so bad that Google has got everybody's data and is using it? They can make better products. Consumer benefit, right? So this is the general posture, which is alien to many here, to most here, but it is very much the position which is being held. And I think, just to give you an example, which I feel very strongly about, again, I think the Google Fitbit merger of last year is the poster child for this. Of course, many in this community, in civil society, were incensed and agitated by that. I and other economists who are more on this side of things tried to create a movement and wake people up to what was actually happening. The conventional way in which that merger was analyzed was, well, you have Google here, they do search, and then you have Fitbit, they do a wearable. They don't overlap. What's the problem? The only concern was maybe other wearable manufacturers are worried that when Google owns Fitbit, then there might be a reduction of functionality when their wearable kind of goes onto Android. Okay, interoperability problem, I get it. But there was really no interest for the data implication, or a limited one. The Commission was willing to go as far as to say, okay, Google don't use Fitbit data for targeted advertising. But Google is already hyper-dominant in targeted advertising. It's not as if the precision of the targeting is going to improve massively as a result of using the health and fitness data of Fitbit. The real issue is you had a monopolist with a data fire hose which was acquiring very precious, very valuable data that could be used in additional fields to make targeted offers in insurance, in healthcare, in other spaces. And that is not necessarily a good thing, because when you have competition in these things, maybe, but when you have a monopolist doing that, it is not really something which benefits consumers, and where consumers will get the surplus from that activity. And we tried very hard to get the European Commission motivated by that, and the posture was too speculative, who knows, more asymmetry, more symmetry of information. If Google gets more data, better products, go in peace. And so that was a case which I think epitomizes the total failure of the antitrust community to have this vision, and at the same time, what needs to be done. I want to conclude with echoing Johnny. There are tools that are powerful potentially. In antitrust, we talk about line of business restrictions, right, as a potential remedy to problems. So you're a company, you are not going, there is a conflict of interest in what you do, we may restrict you from going into that sort of area. That's not a million miles away from purpose limitation. You can use that to support and assist and complement antitrust enforcement. No one is here saying, and hear me out, that one needs to pursue privacy and data protection goals to antitrust. Wrong. No one says that. But I'm saying the tools of data protection and privacy can be very useful to assist, as Johnny said, competition enforcement. If competition enforcers bother to try and understand what is going on, because one of the real problems is also that there is very little understanding at the antitrust agencies of, for example, what data does, what data is used for. The CMA in the UK is a unique agency which has tried to develop capabilities in data analytics and in that space, but in France a little bit, but nowhere else. So this is a total black box. If you go and talk to the antitrust regulators about what exactly is the data supposed to be doing here, blank. No one knows. So I conclude with sorry, I went over my time too, but I think there is work to be done, which is really holding the feet of antitrust agencies to the fire, hearing what this community has got to say, because the insights are useful and powerful, and leaning on antitrust agencies to take them on board. Thank you.
Thank you, Christina. Renee, try to cheer us up from the other end of the call. You've been the driving force in the European Parliament behind the Digital Markets Act. You wrote in an article just before the political agreement was reached that the Digital Markets Act can be the alternative for long and uncertain competition cases, and that unlike the GDPR, it would address market dominance in digital advertising. Tell us how you expect it to be different, how it could ameliorate some of the problems which that Johnny and Christina have been discussing.
Thank you, Christian. Thank you all also for the invitation to speak at this conference. I'm still a bit new in my role as a politician, so as a member of European Parliament, as you have introduced me, because I'm actually a learned academic, though my chair has this interesting name of being a professor of public and private interest. What I am is I'm a trained EU lawyer and competition lawyer. So in that sense, there's at least one competition lawyer in the room, yet digitally, not physically. And that makes it that when looking at the DMA, I have very much a competition law perspective on it. And I use this perspective that I have as an academic in the negotiations, in the final negotiations of the DMA in which I participated. And in order to see the potential that the DMA has, I believe we have to reflect on the shortcomings that the two other fields of competition law and GDPR have. And Christina said already a lot about the shortcomings that competition law has. And I think it is really worth to briefly remind us of this, that we have a mindset problem, and this mindset problem is indeed linked to the American city of Chicago, and the very idea that competition law is meant to increase consumer welfare, and is being obsessed with consumer welfare standard. And I think that the worst about the relationship between competition law and privacy law could be seen in the justification of the European Commission in the WhatsApp Facebook merger, in which the Commission said there are privacy issues, but that doesn't concern us. It's not a merger problem, and continued with the analysis and concluded then that the Facebook WhatsApp merger could go through. So we have this mindset that everything is to be looked at the consumer welfare. And here we have to be honest. A good legal act like the DMA will not change the mindset. It will make clear that the legislator might have a broader perspective than the majority of those who are working for B2B. But it doesn't take away that the mindset is still on consumer welfare. That makes it why events like this today and any others in the future to come are so necessary, and they must be repetitive, because the message must continue to be given that consumer welfare, at least when we look at digital markets, is not the right standard, but it has to include also privacy issues. Now, what are the further shortcomings if you go a bit more on the technical level of competition law that we do have there? The first one is, if you look at cartel control, then the European Commission needs to prove an anti-competitive effect. The European Court of Justice is very tough on the burden of proof on the Commission, so that means there have to be a lot of detailed market investigations. And the Commission is losing quite some cases because the Court of Justice doesn't think that the anti-competitive effect was proven properly, especially if we have vertical restraints, such as Google buying Fitbit or something like that. Then you even have to assess it against the pro-competition effects. Christina was just mentioning it. But I think more relevantly here is, if you look at the data giants, they have a monopoly position on their respective markets, certainly being gatekeepers. Competition law says dominance or even a monopoly is not a problem, but it's abuse. Yet the abuse has also to be proven and requires a lot of investigation. And that makes it that competition law is very slow. But at the same time, it is very tough, as obviously everybody who wants to enforce something in this European Union tries to squeeze it under antitrust or tries to squeeze it under state aid. It's a sword that hurts. Yet, and the reason why so is because we can have quite heavy fining decisions. Yet if you look at our data giants here, Johnny was showing it in his slides earlier, the fines that were dissuasive in, let's say, Industry 1.0, they are not at all when we look at digital markets. Apple and Google are not very impressed by fines. We have this famous case at the Dutch Competition Authority in which Apple just continues to pay the fines instead of changing the business model just because it's more beneficial to them. So therefore, fining is not the solution. That shows us where the shortcomings in competition law. The shortcomings that we have in privacy law and GDPR, they are also well known. We have excellent law if we look at the regulation. We have the purpose limitation principle in the GDPR. Everything is already written in there. That makes it also, there's no need to repeat it. Yet what we have as a shortcoming is it's extremely weak when it comes to enforcement, having small national supervisory authorities such as the Irish one having to deal with all those data giants. They are not able to, if you want to say it positively, they are not able to manage all this this amount of work. If you want to be a bit more cynical, it is of course within competition in the European Union a competitive advantage to say you have a more reluctant privacy or authority. Plus we have the issue, of course, of dark patterns that all undermine the beautiful construct that we have built in GDPR. So these are the shortcomings, and the question whether the DMA is better is to see whether they address these shortcomings that were just mentioned. And in my eyes, they do. Because the way of how the DMA is designed, it is not a competition law instrument. It is a regulatory instrument. It doesn't require lengthy market investigations in order to prove an abuse or an anti-competitive effect, because we as a legislator have determined that if certain thresholds are met, then those gatekeepers are subject to it, and then they are subject to those obligations. That makes it that that the DMA can be made easier applied and implemented as we have it under competition law. Secondly, and I think here it becomes even more relevant, we have included a new way of dealing with the enforcement issues. And here as a lawyer, I must say any law is only good as its enforcement. And whilst we are following when it comes to the first in non-compliance, the competition law procedure having fines up to 10% of the annual turnover, it becomes interesting if we are in a situation of systematic non-compliance, because then a beautiful new rule will apply, the possibility for structural remedies. And that is going where that's where it's going to hurt. The European Commission is now empowered in that situation to adopt a decision, for example, prohibiting killer acquisitions. And there is no need anymore for market analysis, pro-competitive, anti-competitive effects, etc. It's prohibited, end of the story. It is a sanction. And the text goes even that far. The text goes even that far that the European Commission could order a breakup of the company. These are structural remedies. And that is the kind of stuff that those giants, they are really afraid of. They are not afraid of fines, but they are afraid of structural remedies. So therefore, ultimately, all what now depends on is whether DG Comp will be able to enforce the law that is made. As a legislator, we did our job to write, in my eyes, good law. And now the enforcement side comes in. The problem Johnny was mentioning earlier, for example, legally speaking, it is not a problem. My reference to the GDPR purpose limitation is part of the DMA. The question is whether the European Commission is making now use of it. That requires first, it's DG Comp who is going to be responsible for it. That the DG Comp people understand what is meant by it. Second, that there is enough men and women power in DG Comp to actually deal with those cases in order to make use of it. And then third, that the Commission is also eager to go through. Christina mentioned it already. Merger regulation is another piece of beautiful legislation, yet the Commission mostly approves any requests that were submitted to it. So it also requires the Commission to be tough politically to actually make use of all the beautiful tools that we have created for it. So that means we are now turning to the enforcement phase, which I believe, legally speaking, the basis is there. Now DJ Comp has to act. And I believe that is precisely where the role of the community also comes, to just keep pushing on DJ Comp to act, to show them that consumer welfare is just not how it works in digital markets, that therefore the privacy issues are even more core to see how market power is defined, and therefore making use of the tools that the DMA is providing for that. Thank you.
Thank you, René. Barry, you have a historical perspective on these matters. Monopolies rise and fall, business models come and go. Why do you think the privacy community should be concerned with anti-monopoly tools, and what are your reflections on the DMA in particular?
Thank you all. It's great to see you all today. Sad not to be there. I was supposed to be. I intended to be. Unfortunately, today, in about 2 hours, I'm supposed to speak to the full staff at the Competition and Markets Authority in London. So I was not able to make it. Some of you may remember that Christian and I were actually on that same stage back in late January of 2018, and we had a panel that included someone named Lena Khan. That's a lot has changed since that panel. A lot has changed for the good since we were on this stage the last time. Anyways, just going to make sort of 3 quick points, I hope. And the first is, like, what is the problem? And, in taking it from a historical perspective, it's actually pretty easy to answer. The problem is power. The problem is concentrated power. The problem is, I'm just going to say this over and over again, power, power, power. That's what political economy is all about. It's about regulating power. In this case, we have power added to data. Actually, we have power in the form of a platform monopolists that control entire marketplaces, in fact, often multiple marketplaces. They control the access to these marketplaces. Plus, they have almost infinite amount of data on every single actor in that marketplace, everyone who's selling and speaking, everyone who's buying and listening. They know everything that's going on both sides of the market. Third thing these corporations have is a license to discriminate. They have the ability to manipulate the flow of information across these platforms, to manipulate how people talk to one another, to manipulate how people do business with one another. I mean, let's understand the business models of Google, Facebook, and Amazon is that they are manipulation machines. They make their money from selling their ability to manipulate you to someone who's going to pay them what's called advertising dollars. It's not really advertising, but they call it advertising. So they created the world's most powerful manipulation machines, and they rent those out. They rent them out to Procter & Gamble. They rent it out to Unilever. They rent it out to Vladimir Putin. They rent it out to the Chinese government. They rent it out to whoever's got a dollar in their hand. These are, we should understand also, these are extortion machines, because they can use these machines to extort power and extort voice and extort wealth from all the people who need to get to market. They are fear machines, because they can impose fear on whoever it is that needs to get someplace, especially if you're a business that needs to sell. They can say, no, today you're cut off. And then that creates fear. They're atomization machines. They break the public apart into little pieces so that it makes it hard for us to work together, to understand, how to fix the problem, because we're all getting different information. We're all being treated differently. These are the gravest threats. Let's just be clear. These are the gravest threats to our democracy, to our personal liberties since the end of the Second World War. By far. Second point I want to make. We have all the tools we need to fix this. I'll just name two from the U.S. perspective. The Interstate Commerce Act of 1887. That was a Railroad Regulation Act. It was a non-discrimination act. It said the railroads could not discriminate in how they treated the people who rode their rails. They could not give them different prices. They could not give them different terms of services. Now, all those railroads, this is a long time ago, but those railroads had all kinds of data they were collecting. They knew everything that was going on the railroad. They knew what everyone was doing because they were carrying everyone's freight. They had all of the information, and everyone else who depended on them had no information. They only knew their own little part of the marketplace. They only knew what they personally were doing. The Interstate Commerce Act of 1887 was the world's first privacy act, because what it did is it took all that data that the railroad had and said, you can't use that data to manipulate people. You can't use that data to extort people. So they took all the power out of the data. The Sherman Act of 1890, that was designed to provide structural fixes so that people could reinforce the fundamental rules that were put in place by the Interstate Commerce Act in 1887. We also have now privacy law. As Johnny was showing, purpose limitation can create structural limits, very much similar to what we have in antitrust. So we can use traditional anti-monopoly law and traditional and smart privacy law to reinforce each other. And we can achieve what we need to achieve. We have all the tools we need. Okay, just real quickly, 3 battlegrounds. We got to look at this as we have to be fighting on 3 battlegrounds. First battleground is ideology. Now, Renee was mentioning the fact that we have this problem called Chicago School. That's ideology. Now, and we're actually winning that battle right now. President Biden, last July, took the Chicago School and he pointed at it and he said, just about every ill that we faced in our country and around the world due to concentration of power is due to this idea. And we're getting rid of it. We're getting rid of this idea. The DOJ in the United States and the FTC in the United States are now working to figure out how to get rid of these ideas in the law. So in the United States, we're going through a revolutionary rethinking of ideology when it comes to dealing with these organizations to get rid of the ideas that got us into this problem, the Chicago School ideas. Second battleground, law. We're working on better law. You have actually a long list of laws that you have passed. GDPR, DSA, DMA. You're working on the Data Act. This is fantastic. You've done a lot of work. You've achieved a lot. United States, we have Senator Klobuchar's bill. We're actually, it looks like it's going to the floor. It looks like we're going to get that passed. We have an important law that's going through New York State. All these laws, each one is fantastically imperfect. Each one of these is not very powerful, if we're honest. But if you add them all up, they start to bite. They start to create interlocking systems of power that actually affect the business models and power of Google, Facebook, and Amazon. That's good. Last thing we need, the last battleground, enforcement, order. In the United States, we've seen a bunch of lawsuits that have been brought. They've been brought by the individual states themselves. The individual states in the United States have brought cases against Google and Facebook. We've seen the federal government getting back into the business. They've brought cases against Google and Facebook, and they're working on cases against Amazon. They're working on lawmaking to deal with these powers. Again, it's like, you know, they should be doing more, they should be moving faster, but they're moving. Then we get to the EU. We get to DG Comp. And here we see an agency that is AWOL, absent without leave. They are not doing their job. Let's face facts. And like, you know, Christina before mentioned the word Fitbit. We just say this over and over and over. Fitbit, Fitbit, Fitbit. Everyone in that audience is a privacy, you know, cares about privacy. Fitbit is one of the great privacy violators of all time. Google bought Fitbit to make itself an even greater privacy violator, and no one did a damn thing. Fitbit, Fitbit, Fitbit. There's your failure. Failure, failure, failure. So what are we going to do? Enforce the law. All your efforts on the legal front are worth naught without enforcement. 2, get rid of the consumer welfare ideology. Renee was talking about this a moment ago. Get rid of it because it blinds you to the problem. Number 3, speed your enforcement up in every way possible. Renee was saying, well, if you need to just prohibit acquisitions outright, well, do it. You know, do whatever is necessary. Do not wait on the United States to fix this. Do not wait on South Africa and Australia to fix this. That's pathetic. The European Union is one of the most powerful institutions in the world. You have a job, you have a duty, get up and do it. And if your enforcers are not doing it, then you in that room have a responsibility of getting in their face and forcing them to do their work.
Okay, well, thanks, Barry. Before we open it up to questions from the floor, can I just come back on, I think law we've covered. We've got laws, plenty of them. Now, perhaps this is a question more for Johnny or Christina. Do you think we have an ideology problem in the EU in the way that many in the US have come to realize they had in relation to the Chicago orthodoxy? And then secondly, on enforcement, what is, Renee was talking about, there needs to be enough people to enforce. How many is enough people to enforce, given the structure of these digital markets?
So there is as ever, a host of factors that effectively are behind the reasons why we don't enforce effectively. Certainly, the lingering and predominant effect of the consumer welfare Chicago school, which essentially is narrow and tends to push people towards very narrow assessment, is very much important. You have discussions now, if a merger doesn't create a horizontal overlap, as is known, or doesn't create a vertical link, it's okay. But what about mergers that create perhaps a strengthening of ecosystem power? We don't have the tools, amazingly, to look into that, to block deals on that basis. Yes, if there is a concern about tying and bundling, Andreas Moon talked about this. Perhaps we should come up with a different standard, because the current standards, which are rooted in the last 40 years of tradition, are incredibly difficult to do anything with. But there's, of course, a number of other things. This stuff is grotesquely gained by companies. It takes a very long time to do it if you want to do it properly. And of course, if you look at the vignette of how the Commission has actually enforced, with all good intentions, against Google, just kind of cast your mind back. Around 2012, 2010, they start saying, oh, there's a complaint about shopping. Was comparison shopping really a fundamental priority? But no, there was a complaint, so we go after that. And everything gets focused on that. We investigate comparison shopping and Google says, well, would you like some RFI responses? Please send me your question, we'll respond. Meanwhile, they shift the monopolist from the desktop into the mobile space and do Android, and then the Commission goes, ooh, whoa, what happened over there? They moved, we need to send them some questions. So the whole thing proceeds with incredible lags and delays, which makes it impossible to enforce effectively. Because by the time we've done Android, then the monopoly has moved to the Internet of Things, and it has moved to cars. So none of this helps. The discussion that René had was of course on point, because the reason we shifted towards regulation is to kind of deal with this problem that exposed we just can't deal with it, because it's always too little too late. So if enforcement of the regulation is possible, then that is certainly a major step forward. Personally, I would like to be more optimistic. I'm not that optimistic, because the regulation is good intentioned, but there is going to be a considerable effort required to make those rules implementable, in the process of which companies will say, oh, you're talking to me? I don't know who you're talking about. Send me a fax, okay? So this is the difficulty. It will need to happen, but I'm not that hopeful, particularly when you're doing nothing on the merger front, that this new regime will tame. And that's why the privacy data protection tools, which are real and now, can be important in trying to knock at the door and say, well, let's do this at least. That's me.
I think that's enough.
That's enough.
Great. Any questions from the room?
There's someone at the back.
There is someone holding their hand up, Christian. Would you like that person to be described to you? So that they...
Give them the microphone, please.
Oh, yeah, it's working. Great. Thank you. Hi, I'm Pratham. I'm studying law and technologies at Leiden University. I have a two-pronged question, so I've written it down. I understand how purpose limitation would severely restrict data flow, which is arterial to the organism that is your typical tech giant. Another major issue in competition law with regards to online platforms is market definition, which is what allows these giants to push themselves into niche markets and engage in killer acquisitions in the name of conglomeration mergers rather than vertical mergers. So would allowing for a prospectively broader market defining characteristics, would that be complementary to the purpose limitation method, or would it be a detriment? And if we do go ahead with the purpose limitation method, how do we deal with the consequences of restricted data flow once a legitimate, quote-unquote, legitimate merger is allowed?
May I take the restricted data flow and you take the market stuff? So let's think about restricted data flow. Restricting something sounds like that thing should be allowed to flow, right? But not all things should be allowed to flow. So let me give you a practical example. If I'm in a car, that does not happen because I don't drive, but if I'm in a car and I'm trying to get to, I don't know, I'm trying to get to a medical clinic for a particular STD or something like that. I'm trying to get from location B to location A, and I'm using a company's mapping system. to tell me how to get there. Now, there's at least one processing purpose involved, possibly many, and I will be very content with those purposes. However, let's imagine I hit a traffic jam, and I and 20 other vehicles are going slower than the average in that location. If the data that are being used to get me from A to B are also used with no risk to me, and I would say it's a compatible use, right, to show that in this general area, the roads are slow, so that other drivers benefit from that, that is not the kind of thing that'll fall afoul of the purpose limitation principle, because it provides for compatibility of processing purposes. Having arrived, though, at the STD clinic, if the fact that it's likely that I am afflicted with that particular STD were to go into some profile about me and that were sold to an insurance clinic, or a red flag was put up on a dating app or something, you can imagine the hypothetical situations. That's quite another story. And yes, that would be restricted. So the benefit that I can get from A to B is provided. The benefit that you can have a traffic and understanding of it is provided. But the hazard, and some economists would say benefit, that I described for the insurance and dating app industry is restricted. Unless I'm asked and I say, yes, have at it, which I wouldn't, because I don't drive.
I don't know that I've got much to add. You know, the way I think about purpose limitation is a very important potential way of actually trying to make sure that the motivation for many of these deals, which is I'm going to get all of this data and then I'm going to do a data free-for-all internally. I'm going to do what the hell I want with it. And no one's stopping me, because this is the motivation of many of these deals. That motivation is somewhat contained. That is what purpose limitation, properly enforced, should be doing. I wouldn't confuse this with market definition and all this kind of nonsense that competition law kind of entertains itself with, because we know that market definition is a complete snake oil activity, and you know, it gets done at the end of the case once you've kind of done your analysis, and now what is going to be the market definition that fits? So I wouldn't mix the two. Purpose limitation has an important potential function, which is, look, if you get this data, you can't use it for all this free-for-all. Well, that's kind of powerful, because then it should stop some of the things we worry about.
Let me just jump in really quickly, sort of reinforcing what Christina just said about market definition. It's like market definition is a pathway to perdition when it comes to dealing with monopolies. It's just like it's how the economists and lawyers make all their money. You know, it's like it serves the public nothing. It achieves nothing. You know, we in the United States we used to have bright line rules. And we as an organization and other organizations are now pushing hard to restore these bright line rules. Bright line rules means if you control a certain, if you control a platform, thou shalt not engage in any businesses that put you in competition with other people who use that platform. That's a bright line rule, straight up. Bright line prohibitions on behavior, thou shalt not discriminate. That's, you know. So for 200 years in the United States, we had bright line rules on structure and bright line rules on behavior, and they worked. For the last 40 years, we have not, and we got into the problem we're in today. So the way to deal with taking purpose limitation in the real world is through bright line rules on structure and behavior, where you just say, thou shalt do this, period, the end.
Yeah.
Thanks. I can't see the room, so I don't know if there are other people who are looking to ask a question.
Yeah, I think there's someone.
Yes.
You want to ask a question?
Yes, definitely.
Go ahead.
Definitely.
Are there a few? Because we could take 2 or 3 together.
Yeah, I think for now nobody's in line, so I'll just go ahead and ask a question first.
I can't hear you.
Can you hear me now?
Yes.
Yeah.
Now.
All right. Great. Well, thank you very much, first of all of the panelists, and I particularly want to thank Mr. Barry Lean for what I think was the great articulation of the central issue. that we're discussing. So my question, just to put it out there, is why are we not prohibiting the business model in the first place? So we talked about it quite extensively, that we have a lot of body of work in legislation, like we have a DSA, DMA, Artificial Intelligence Act, we have GDPR, we have unfair commercial practices, and all of this seems to like dance around the topic. And even the description of today's session was that central business model remains unaffected. And my question is, like, for example, we discuss antitrust laws and you know, breaking up these companies, but we are not talking about prohibiting the business model. I mean, if we are going to regulate the symptoms, but whatever creates the greatest harm continues, then what are we really doing this past decade? It seems that we're just like entering like this self-perpetuating contemplation, but that's my reflection. So question, again, to repeat, why are we not prohibiting the business model that, as Mr. Barry put, is in the manipulation machine? And on the point of ideology in the Chicago School, I just wanted to add that in Chicago, we also have, you know, University of Chicago people like Martha Nussbaum, who suggests capabilities approach to a way to measure human well-being, and rather than remaining it with the consumer welfare. So Chicago not only produces the evils per se. So yeah, that will be the end of my question, and please, yeah.
Christian, do you mind if I give a very brief initial answer?
Sure, and I'd like to ask Renee to come in on this as well, please, because it's I'd be interested if this question was raised in the discussion on the DMA.
Sorry, I didn't hear.
Okay, I'll go ahead, and then Renee, I think. First, the title of the panel does not have business model in it. That's a different panel.
Sorry, not the title, the description. And it does have it.
Okay. But I was going to say, but you're right. Second, the business model, as it's currently practiced, is definitely unlawful and has been unlawful for a terribly long time. So the second question really for us is not about enforcement in competition, but enforcement in data protection. And there's plenty of panels about that, and it's a live and pressing problem. I agree.
Yeah, just to add on that, if I may, apologies. I understand that, and I personally think that purpose limitation is a great tool from the data protection perspective. But when it comes to the unacceptable practices or unacceptable risks, there are no trade-offs, right? Like, we have the concept of human dignity. The data protection allows these trade-offs, this proportionality discussion, while in some cases this shouldn't be the case. So that was my question. Like, yeah, there is Article 22 with the prohibition of the automated decision making and stuff like that, but still there is no outright prohibition of, let's say, manipulative practices when it comes to behavioral advertising, for example.
Do you want Renee to jump in?
Yeah, Renee, could you come in? I'm curious, in the light of that question, whether you know, the basic issue of business models as opposed to individual behaviours, the do's and don'ts, the DMA, whether that was discussed and what the conclusions were.
This was, of course, discussed, and the point is, of course, business model is a very broad notion. Hence, when we are talking about the nitty-gritty of how making a law, we have then to get criteria that are precise enough so that later in the application we get smooth application. So that's for the basis. Hence, what kind of business model are we talking about? What we did in the DMA was that very harmful business models, they were indeed prohibited, such as tying and bundling exercises, such as preferencing, etc. We had a lengthy discussion about a business model where the harmfulness of which was debated within a legislator, that is in particular targeted advertising, and where I have to admit that my personal position is to completely ban this, and not only target at the most vulnerable ones, but this position did not even find a majority in Parliament. When we were discussing the prohibition of targeted advertising in the DMA, it was not, we got a deal with the council that said this prohibition is to be put in the Digital Service Act, and there you find it now. target advertising targeted at minors or based on sensitive data is prohibited there. So there you see we have prohibited certain business models, but they were precisely described so that later in the application it is possible to be done. What was this ringing now?
5 minutes left.
5 minutes left.
Last round. I see. No, but in that sense, I'm at the end of my statement already. So we have prohibited certain business models in a very specific way. We have made other business models to be more difficult to realize. And besides, we have to see that, of course, there is a market going on in digital markets, and there's business activity which is also not harmful and should continue to be done. In that sense, I do think we have struck quite a good balance in prohibition and allowing.
Thank you.
Can I add something, Christian, to that in the last couple of minutes? Look, I feel strongly that business models are a very interesting way to think about it because, of course, each of these digital platforms are funded and monetized in different ways, right? And we think about the way they do things as a function of how they monetize, and so they monetize in different ways, and they have different incentives for doing good or bad things. Now, if you mean by prohibiting business models a position that we do not want any tracking, for example, in advertising, I have personally some sympathy for that. In the same way as I have sympathy for bright line rules, because I think one of the problems of where we are, and I don't want to put it at the door of the Chicago school, that's reductionist and simplifying, but we certainly have moved away from a world in which we had presumptions to a world in which we, the economists, were selling the notion that we need to look at everything case by case because even a monopolist can be efficient. And it's kind of gone for 20 years and more, but the point is that in the current political economy situation, which is acute, I don't think it is conceivable that we can look at things one by one and make excuses and build models and do this and do that. There need to be more bright lines in the way that you're saying and Barry's saying. And I think the case-by-case individual analysis is really what has led us here. It is unmanageable. It is not actionable. It is not practical. We need to move away from the notion that we can spend 7 years on a case and resolve it. We can't. So I think that's why we need something ex ante and we need it bright.
Okay, we've got a couple of minutes left. Let's try and end on a bit of hope.
There is a question.
There's another one last question. Go ahead.
Okay.
Thanks a lot. Indra, speaker of the University of Frankfurt in Germany. Thanks a lot for this great panel and these great analysis. I just have 2 questions, or I would like to ask you for your assessment of the future. If we combine data protection and competition law, the way you described it, one of the problems is going to be the burden of proof, very rightly so. What tells us that the European Court is going not to take over the burden of proof regulation that it has assessed over the years from the competition law to the data protection area, which would basically just transfer the same problems what we have now? And the second thing is competition law always regulates economic activities. A lot of the data protection regulation is not originally at least designed for economic protection. There's only so much of consumer protection in it, et cetera, et cetera. So how do we solve the problem, or how are we going to solve the problem that we have to assess what type of regulation of the GDPR is actually with an economic background and what's not? It's easy with purpose limitation, but how is it with other areas? It's easy with data portability, yes, but what do we do with anything in the public sector, in the health sector, et cetera, et cetera? Thanks a lot.
Well, this is an excellent question. I'll say something and then, Johnny, you close. Look, as I said, I think we cannot, he'll close, yeah. We are not suggesting, and I'm certainly not suggesting, that we need to pursue things like GDPR enforcement with an economic hat on. GDPR is GDPR and needs to be enforced on its terms. My plea is that we need to import what this community knows into antitrust assessment, where it is an economic assessment. There is knowledge. There is knowledge of what the data means, how the data is used, Johnny's spreadsheets that make babies. That is totally news over in antitrust world. And it isn't about enforcing privacy and data protection with an economic hat on. I get that. These are other values. But where I sit in the antitrust community, I feel there is a massive gap in understanding, which makes the enforcement really weak. Because then you are into this world of it's all uncertainty, we don't understand it, it is a black box, what do we know? We don't know what they can do, maybe it's a good thing. And you're right, I mean, in Luxembourg, judges everywhere are not necessarily always, progressive and forward-looking, but it's a problem that's global. It's true in the United States, it's true here, and I don't think it needs to stop us. Christian, sorry. Go ahead.
Thank you. I think we're out of time, but I wanted to hand over to Barry to end on an optimistic note.
Yeah, no, it's
send people
really
off to lunch.
Yeah, I know you're off to lunch, but really quickly, I think it's really important for folks to understand we are winning. As bad, as bleak as it looks right now, as dark as it is right now, it's the fact is 4 years ago, when we were last there was an academic who was working for the Open Markets Institute, Lena Khan, who was part of our panel. She is now the chair of the FTC. She just got her third commissioner, so she can really start to rip into big tech, into these issues. She understands these issues. Jonathan Cantor at the DOJ understands these issues. Even President Biden understands these issues. So it's like the corner has been turned. We are on the march. We have an immense amount of work to be done. The faster the folks in Europe sort of join and fight with us and fight on these battlegrounds, the sooner we all win. We need to do this together. And when we do it together, we will prevail.
Well, thank you all very much. Thank you to our speakers. Sorry I can't be there, but I'm sure you can all enjoy an intoxicating drink with Johnny now. So have a great day.